Hello everyone and welcome to this IP Insights video. Today I'm talking to my colleague Georg about the differences and pros and cons of UPC revocation actions versus EPO opposition proceedings. Georg, what do you think are the main differences between these two types of proceedings that one has to consider when assembling a strategy for challenging the validity of a European patent?
Well, Patrick, in my view, the three most important differences are territorial scope, timeline, and costs.
I fully agree. Presently, a European patent can be validated in up to 39 member states. Therefore, an EPO opposition proceedings may lead to a revocation in all of these states. In contrast, the UPC has presently 17 member states. Therefore, a UPC revocation action may only lead to the revocation in a much smaller number of jurisdictions. Isn't this a major disadvantage?
Well, not necessarily. Of course, an EPO opposition, in theory, has a much bigger territorial scope. But in practice, most European patents are just validated in maybe 4 or 5 countries or less. And if those countries are UPC member states, UPC revocation action may indeed be a viable option to go for, especially if timing is of critical importance.
Indeed, timing is an important factor. On average, it takes 21 months to get a first instance decision in opposition proceedings, which is a relatively long period of time compared to a revocation action, of which we presently assume that it will be decided within less than 1 year. Moreover, a revocation action immediately starts upon filing, whereas in opposition proceedings can only start after the lapse of the 9 months opposition period.
Correct. So if the time to a first instance decision is the most important factor, the UPC revocation action is therefore certainly the preferred option. But one also has to keep in mind that it typically entails a higher cost risk compared to an opposition.
Correct. A UPC revocation action comes with a risk of costs due to cost reimbursement claims. However, this can be seen as an advantage. If you have, for example, a strong case, the loser would have to cover the costs of the winner. Another interesting option is that opposition proceedings could be filed in parallel to a revocation action.
Yes, presently there's no rule that would prevent one from filing both simultaneously. And it can indeed be an interesting strategic option to start with a fast-track UPC revocation action and then potentially introduce the insights of these proceedings into the opposition proceedings that are filed later on after the lapse of the 9-month opposition period. Also, it may make sense to go ahead with both if, for example, non-UPC member states are at stake, such as the UK or Spain.
So, Georg, what are the main takeaways our viewers should keep in mind?
Well, first of all, keep in mind that UPC revocation actions will be decided on much quicker than opposition proceedings. Costs may be higher, but there's also the potential benefit of cost reimbursement claims. Finally, also territoriality is an important factor. And if countries such as the UK or Spain are decisive, going for an opposition may be the right choice.
Thank you, Georg, for this summary. I hope these considerations are helpful in deciding which type of revocation proceedings is the right choice. If you're interested in more videos like this, please visit the Bartele Parkenberg YouTube channel.